Hello, I'm Valerie Nannery, Senior Director of Network Advancement at the American Constitution Society, the nation's foremost progressive legal organization with more than 240 student and lawyer chapters across the country. You can find us online at acslaw.org, where you can become a member and find more information about upcoming events, including our 2022 National Convention, which starts tomorrow. You can still register to join us virtually for 2 days of conversations and workshops about some of the most urgent and challenging issues facing our country. It is my pleasure to welcome you to the final event in our pre-convention series of book talks with the authors of the books on the ACS summer reading list. Today, we are excited to be joined by Elie Mystal. Elie is the nation's legal analyst and justice correspondent, an Alfred Nobler Fellow at the Type Media Center, and the legal editor of the More Perfect podcast on the Supreme Court for Radiolab. He is a graduate of Harvard College and Harvard Law School, a former executive editor of Above the Law, a former associate at Debevoise and Plimpton, and a frequent guest on MSNBC and SiriusXM. Elie will be discussing his first best-selling book, Allow Me to Retort, A Black Guy's Guide to the Constitution, with Assistant Professor of Law at the University of Michigan Law School and co-host of the Strict Scrutiny podcast, Leah Litman. Professor Litman teaches and writes on constitutional law, federal courts, and federal sentencing. In addition to her many law review articles, Professor Litman has written for popular audiences in the New York Times, the Washington Post, Los Angeles Times, and Slate. She is also a co-creator of Women Also Know Law, a tool to promote the work of women and non-binary academics, and she maintains an active pro bono practice. Leah and Elie, thank you so much for joining us today. I'll turn things over to you, Leah, to kick things off.
Wonderful. So thank you so much, Valerie, for that introduction. I'm super excited to be here with Elie to discuss his book. And I just want to note at the outset, if you have a question for Elie about his book, Allow Me to Retort, please use the Q&A box at the bottom of the screen. Don't use the chat. The Q&A box is much easier for us to keep track of for questions. And we will go over the questions, throughout the conversation as you put them in. So, alrighty, let's go ahead and get started. So Elie has written this wonderful book, Allow Me to Retort. And I want to start out with, one of the conceits or premises of the book and situate it within the conversation today. So on page 1 of the introduction, very first, you write, "You rarely see liberals make the point that the Constitution is actually trash." This, of course, has been one of the favorite things of Republicans on the Senate Judiciary Committee to highlight. And I have to start there in part because this is the American Constitution Society, an organization that is dedicated to trying to ensure that the law, including the Constitution, is a force for protecting democracy. If, as you say, the Constitution is actually trash, what are we doing here? Should ACS change its name? Are we in the wrong business? What's your advice to us?
Thank you so much, Professor Litman, and thank you everybody for having me. Yeah, it seems like Republicans read the first page and didn't quite make it to the second page, where I contextualized that statement a little bit more. No, I do not think the ACS needs to change its name. Right? The Constitution is an idea. And there are ideas in the Constitution that are good and positive and well worth fighting for. The problem is that the execution, there are two problems. One, it also contains some pretty horrible ideas, right? The idea that I'm 3/5 of a person, the idea that anybody who sees me free should recapture me and send me back to my master, the idea that women aren't people at all. There are some bad ideas interspersed with the good ideas. And the biggest problem I have with the Constitution is that the execution of its relatively good ideas is, shall we say, poor at best. The ideas in the Constitution have never once been made real for all of the people living here at the same time. Not even for a day, just to see what it would feel like to live in a free and equal society. We haven't actually tried it. So if you want to defend the idea of the Constitution and bring those ideas to all of the people, 100% I'm part of that project. But the conceit that this is some kind of gospel handed down by Moses, folks, let's remember that we're talking about a working document, a summer project scrawled out in a couple of months in Philadelphia, made by exclusively 30-something-year-old wealthy white men, right? Imagine if today, Chris Hemsworth and Daniel Radcliffe wrote a movie, right? No, Scarlett Johansson not allowed to be a part of that movie because she's a woman. Michael B. Jordan, no, can't be a part of that movie because he's black. Zendaya, absolutely not. A brown woman? Are you kidding me? So Chris Hemsworth and Daniel Radcliffe write a movie, and then people claim that it's the best movie of all time and the movie that all other movies in perpetuity should be based on. I say no. Maybe they come up with Good Will Hunting, which is a pretty solid effort by white guys, but like that, this is the only thing that is possible. It's just fallacious on its face.
Okay, so obviously, when we're talking about the execution of the Constitution and it not being fully implemented, part of the blame lies on the Supreme Court that has very minimally read, some of the Constitution's promises, like the 14th Amendment. Part of the blame lies with a Congress that has never really, tried to fully implement, its congressional powers to do things like enforce the 14th Amendment. But a lot of the people in our audience are members or would consider themselves members of, the progressive legal movement. And a part of the book is directed at, people in that movement and what they haven't done, in order to ensure that the Constitution's promises are executed. So could you tell us a little bit about where you think, the progressive legal movement has been falling short on that ideal?
Yeah, so one of the criticisms I've gotten from the book is that I'm not going to convince Republicans with some of my analogies and analysis and examples. And I say to that, what kind of annaled world do you live in where everything that comes out of my head has to be tailored to like a Republican in a diner in Ohio? I'm not trying to convince Republicans. Again, Republicans don't actually agree that I should be treated as a full person. I'm not trying to convince them. I am trying to get people who already agree with me on the basics, right? Who already agree with me on where we should be going, to take the field against these people and to adopt a different kind of war footing when we talk about the Constitution and when we fight for our rights to get into the game. People need to understand one of the asymmetries that we always fight when it comes to the conservative interpretation of the Constitution. And I say conservative because it's not just Republicans, right? Like conservative Democrats believe this. And also, the parties change what they call themselves from time to time throughout American history. I don't care if the conservatives call themselves Republicans, which they do now, or Democrats, which they did during the Civil War era. I don't care what they call themselves. Whigs, whatever. The conservative interpretation of the Constitution is faulty. It is limiting. It is bad. And at some point, we need the liberal interpretation, the progressive interpretation, to really take the field and stop ceding intellectual ground to these people point by point by point, right? Like, we need a different language around this. The asymmetry comes from the fact that the conservative movement has been very good at marketing what they want, right? And marketing it to the rump of white male landowners that stand to benefit most from what they want, and then fleecing other people who will not benefit from the conservative interpretation of the Constitution to think that it's just the objective way the only way to look at things, right? Whereas liberals and progressives, when we try to fight back, we tend to start with like, well, we just want good judges. We just want judges that will apply the law. No, I don't want judges that are just going to be good or apply the law. I want judges who are going to fight. I want people who are going to fight for an interpretation of the law that is more robust and inclusive than what the conservatives have said the law is for the past 250 years.
So two of the specific examples you just mentioned are, one, coming up with like an alternative theory for how the Constitution might be interpreted. And then second, developing priorities about what to do with the Constitution other than appointing judges who will be good and apply the law. Let's start with the first one, developing that alternative theory for how the Constitution, should be interpreted, because a large part of the book is an argument against originalism. And so is the argument that, you mentioned the Constitution contains some good things, some bad things. Sometimes originalism has generated results like, say, the Confrontation Clause, right, recognized in Crawford, the ability to confront your accusers, or the Sixth Amendment jury trial, right, that made it harder for judges rather than juries, to increase a defendant's amount of time in prison. So is the argument against originalism the idea that, on the whole, the original premises of the Constitution shouldn't be amplified today over, our present day priorities? Or is it just about the method itself? Kind of what do you see as the key flaws in originalism?
Yeah. So have you ever seen Lord of the Rings?
Oh, yeah.
Right. So I am of the Aragon school, which is that the weapon of the enemy cannot be used for good. I understand that there are other people who agree with me, other liberals, other progressives, who are in the Boromir school, who believe that if you just give me the power of the ring, I could do it to do good stuff, right? That originalism can be deployed for good. And I just think that's bankrupt, because I think that originalism is intellectually bankrupt. Remember what we're talking about. We're talking about resolving ambiguity in the law, and to resolve that ambiguity based on what the original public meaning of the laws were, that public meaning being tied to what white male slaveholders thought at the time, or a society that allowed for slaveholding. Like that just doesn't work for me. Even when we talk about the amendments, the Civil War, the Reconstruction Amendments, or what have you, if you look at the amendments, you'll find once again, they've been written by white guys, right? Even after the Civil War, we have this whole war, shooting, and then, Grant, and then Sherman, destroy, right? And then we win the war, and then what do? We let the same white guys who were on the good side write the definition of freedom for a whole race of people without asking those people, right? Frederick Douglass didn't get to write the 14th Amendment. He was consulted maybe, and he might have been the only one. Frederick Douglass might have been literally the only black guy that all of the people in Congress spoke to before writing the 14th Amendment. If he had asked the formerly enslaved people what freedom, equality, whatever meant to them, they might have said, I'd like some property rights too. You never know. I'd like equal pay for equal work, sir. You never know what the slaves would have said after the Civil War, because they didn't ask them. So I view tying our current understanding of the law to the original public meaning of the white male, generally slavers, who wrote him, to simply be unworkable. Now, what I am, Leah, and Professor Jamal Green from Columbia has called me out on this a little bit. I am a sneaky textualist, right? I am willing to agree that you kind of start with the text, that in a kind of Kagan sense, that the text is the first place that you look at to understand.
Your confirmation hearing, Elie, will you say we are all textualists indeed?
That might be the only bone I throw to Dick Durbin, right? I do believe that the text has meaning and value and should be a starting point. Where I differ greatly from the originalists is what do you do with ambiguity in that text, right? Textualism can also be bankrupt in different ways that we can get into. But in general, text is a good starting point. But then when the text is ambiguous, what do you do about that? And the idea that what we do is bring out the Ouija board and try to figure out what James Madison really... Get out of my face with that. That is not a legitimate system of government. Because, and this is the last thing I'll say about this, the idea that me as a free Black person in the 21st century is still fundamentally my rights and responsibilities are still fundamentally defined by my former captors. That just doesn't fly. There is no legitimate system of government that requires the former captors to still live under the laws of their former masters. That's just not how it works.
So then the method that you are offering is start with the text. The text is the basis, and then let's not play the game of resolving ambiguities with respect to or with reference to what James Madison understood this project to be. So if that's right, then how should we be resolving the ambiguities? Because one possibility is we ask judges to consult the principles underlying, the Constitution, including the idea of democracy, that I highlighted, at the beginning when talking about ACS. And I think in theory, that sounds pretty good to me. I like democracy. I think our system of government rests on certain premises. I'm really concerned about handing over the ability to determine on what principles our system of government rests and implementing those principles to the current Supreme Court. So how do you kind of get around that concern when proposing a theory that isn't, say, as rooted in, just go look at the history book, Neil?
Right. So the first thing that I say is that I want to resolve ambiguity towards pluralism, right? Democracy, yes, that's great too, but fundamentally towards pluralism, inclusion, and a free and equal society. Like that's always twirling forward, right? Like that's always where we should be trying to get at, towards more inclusion, more diversity, more equality. That's the point. And if you're not doing that, then I find that your viewpoint is bankrupt, right? Or at least doesn't apply to me. Now, does that work with the current majority on the Supreme Court? No, of course not. Nothing works with the current majority on the Supreme Court. You can't outthink 6-3, right? There is no theory that will restrain conservative justices, because conservative justices are not cabled by a theory, even their own. Neil Gorsuch will throw originalism away at the earliest convenience when he wants to do a different thing, right? Last term, we had Neil Gorsuch this term, we had Neil Gorsuch literally saying that an environmental law act was too old to be are you kidding me? Neil Gorsuch, who will literally go and tell me what was on Thomas Jefferson's lunch menu to figure out whether or not a Black person has rights, is now telling me that this, healthcare law, that was just too old for it to be applicable to. Get out of my face. So even the conservatives do not apply their own theories when their theories butt up against an outcome that they want. So there is no theory that restrains conservatives. There is only beating them. There is only flooding the zone with people who want, like I said, a more inclusive, pluralistic society. That's the way forward. You're not gonna fight these people with logic. And I think that's one of the big things that liberals have a hard time kind of understanding. I get all the time on Twitter, on Facebook, responding to my emails saying, oh, well, how can Robert say blah, blah, blah? Because that's illogical or hypocritical, given that Robert said yada, yada, yada. And the answer is he doesn't care. They don't care how good your legal argument, how grounded it. They're gonna make it up as they go along because they want certain outcomes, and they will rule towards those outcomes. The theory that you would call me a legal realist in that sense, right? That I believe that the judges figure out what they want and then backfill the legal reasoning in to get there. And all I'm saying is that I'd like some more people who want what I want. That's the fight. If that's what they're going to do, then I just want more people who ultimately agree with the outcomes that I think are positive.
So maybe we can talk about some of the specific areas of law and where, the court's preferred method of interpretation has taken us and where that's gone awry, and how a more pluralistic and inclusive approach might differ from that. So something that ACS has been very engaged with has been the death penalty and the Eighth Amendment. So could you, talk to our listeners about, what you discuss in the book as to how the court's, approach to originalism has gone astray with respect to the Eighth Amendment, and what a more, inclusive, equitable approach to that provision, what that would do?
Yeah, so I have the argument that the Eighth Amendment is the cleanest battle between originalism and everybody else. It's the easiest part where you can see the difference in interpretation. The Eighth Amendment outlaws cruel and unusual punishment. Does the Constitution define what is cruel or what is unusual? No, it does not. Did the constitutional founding fathers come up with the phrase cruel and unusual? No, they did not. They copy and pasted that from the English Bill of Rights in the 17th century, right? So this is a phrase ambiguous, that is not a word, ambiguous by its nature, that is in the Constitution and not defined elsewhere in the document. How do you resolve that ambiguity? Well, originalists say, well, you got to go back and look at James Madison, look at the founding fathers. Neil Gorsuch has written about how really the difference between cruel and unusual is something called superadded pain, and he went through this whole thing about how punishments that would have readily been seen as wrong to the people who wrote the Constitution could be seen as wrong today, because the thing that they understood was that the superadded pain was what made those punishments horrible versus mere execution okay. And I say, this man forgot about the slaves, because every single punishment that Neil Gorsuch said was in the original public meaning clearly wrong at the time of the founding was done to the slaves. You want to talk about the kinds of punishments that white people did not feel were cruel nor unusual, the kind of superadded pain that white people did not feel was cruel or unusual to bring to an enslaved person? I won't. This is a family program. Like you just it becomes a tragedy porn to actually go through what these people were willing to do. The difference was not whether or not the pain was superadded, but the difference was who the victim was. The founding fathers thought that there were certain things that was okay to do to white victims that weren't okay to do to white victims that were totally okay to do to Black, brown, and Native victims. That's the difference. And so when Neil Gorsuch says that we have to then take the entire Eighth Amendment and put it in the mindset of a founding father who could do this, to say nothing of a founding father who could eat a sandwich while watching a man be hung by the neck till death, I say no. I say that their lack of humanity is not the thing that controls us here in 2021 and 2022, right? That we do not have to be reduced to the best possible idea of a James Madison or an Alexander Hamilton as people are being hung and shot to death. That's not the way. The other way is more messy, right? I understand that. Like, trying to define cruel and unusual punishment as we go is more messy than trying to ossify cruel and unusual in an 18th century mindset. But that is the job. That's why you get the big bucks, Judge. Like that's what we should be going towards, right? So the idea that originalism wants us to look at the original public meaning of monsters, frankly, right? And they're monsters, and even the people, well, they did the best for their time. No, they didn't. There were people in real time who understood that some of these punishments, that some of these tortures were wrong. They just got shouted down. So it's not that they were doing the best for their time. I will allow that there were some things that they didn't know. I will allow that James Madison didn't know the horrors of, let's say, solitary confinement, right? Didn't understand that solitary confinement is torture for your brain, right? How he would have reacted had he known that, who's to say? But also, who cares? Who cares what James Madison thought about solitary confinement? He wasn't as evolved as we are in terms of his humanity, and he wasn't as evolved as we are in terms of his scientific understanding of the brain. We are the ones who know. We are the ones who are supposed to care. So when we impose solitary confinement and pretend that's not cruel and unusual, it is our dishonor that we are bringing forward, not theirs. And so I say, again, what we need to be doing is interpreting that phrase in the Constitution and, elsewhere in the document in a way that goes towards, again, more inclusion, more plurality, and in this case, more humanity.
So I just want to remind everyone that you can put your questions into the Q&A box if you have them. But I want to pick up on one of the criticisms, you just made of the court's approach to the Eighth Amendment jurisprudence, which is, the court's failure to consider, the practices and histories of slavery, when determining, whether we should look to views at the founding to determine what punishments, are cruel and unusual. And this has been, a persistent problem and criticism of the court's jurisprudence that people have raised. Many people are aware of the leaked draft opinion in Dobbs, in which Justice Alito's draft opinion, launches a criticism against the idea that the Constitution protects any rights that aren't explicitly listed in the text of the Constitution. And yet the work of Peggy Cooper Davis at NYU, among other people, has shown that one of the things the 14th Amendment was designed to do was to give, rights regarding families, that were not afforded to slaves to Black Americans. And so it's a repeated failure to kind of grapple with the history of slavery, the Civil War, and the Reconstruction Amendments, that pervades the court's jurisprudence. And that's, one of the, again, main criticisms in the book, that you identify not only with the Supreme Court, but also the progressive legal movement, which is the failure to make good on the potential and promise of the Reconstruction Amendments, especially the 14th and 15th Amendment. So how do we get to, the more fulsome protections that you envision under the Equal Protection Clause, for example?
I mean, you have to appoint justices who agree that the 14th and 15th and 13th Amendments and 19th Amendment eventually, because remember, the white male slaveholders who wrote the Reconstruction Amendments took them another 50 years to, whoa, women, also people. So you appoint justices who believe in a more robust interpretation of those amendments. People understand. Conservatives, again, whatever they were calling themselves, conservative justices have been trying to cut these amendments out at the knees from the moment they were ratified, right? What's the first case that was brought under the 13th Amendment? It was by white people.
What? Yeah.
It was the slaughterhouse cases. It was by white folks who argued that the granting of a monopoly on slaughterhouses, they weren't very creative, in Louisiana, was akin to economic slavery. And there were people at the time, including some of the people who voted for and ratified the 13th Amendment, who thought that was a fine case, who thought that the 13th Amendment should apply to the situation in the slaughterhouse cases. It is the conservative justices who said, no. The 13th Amendment only applies to the, quote, slave race. Their words, not mine. So right at the beginning, right at the very ratification of the abolition of slavery, we have that abolition curtailed in a particularly conservative way. It didn't have to go that way. And then obviously there are lots of cases as we go forward after Reconstruction where the 14th Amendment is just whittled and whittled and whittled down to the rump that we basically deal with today. The 15th Amendment, let me tell you something about the 15th Amendment. 15th Amendment was straight up ignored for 100 years in this country. Conservative justices just took the 15th Amendment, very interesting Congress and three-fourths of the states, put it in a box and didn't open it again until 1965. All right, so the idea that these amendments are what what they are has already been, shall we say, infected with conservative logic and a conservative kind of retrenchment of the rights and grants of those amendments. If you want to change that, you don't need to pass a new 15th Amendment. It's already right there. If you want to change that, you have to have justices who will interpret the 15th Amendment as a thing that exists, which is not what John Roberts does. If you want the 14th Amendment Equal Protection Clause to be more robust, you have to appoint judges and justices who will interpret the Equal Protection Clause as a thing that exists, which is not what Samuel Alito does. So it's a very clear, like, you can have judges who think that these amendments are paper tigers, or if you can have judges who think that these amendments are the whole ball game, and it is a political choice on all of ours to accept the ones who think that it's a paper tiger, and not promote the ones who think that it's the whole ball game.
So one of the examples you gave of, the early invocation of the 13th Amendment was the slaughterhouse cases, in which a group of white plaintiffs argued that, a monopoly created involuntary servitude. Another example I actually give to my students is there were, among the constitutional challenges to the Civil Rights Act of 1964, which prohibited racial discrimination in public accommodations, one of the challenges that business owners brought was that was an involuntary servitude on white business owners, by requiring them to serve Black customers. So just in thinking about, how these arguments can be deployed, you see, let's say one side being very aggressive in how they are pushing them. And, I am not coming up off the top of my head with similarly aggressive or creative arguments on the other side.
White business owners used to argue that the Civil Rights Act interfered with their right to privacy in their own businesses. Here's a more general overview of something that I talk about in the book, and it's important for people to understand. Any argument I make can be used by people who disagree with me to twist it into something else. That's the nature of these arguments. Of course, the other side can use it for ill gains. I actually talk about in the book the Religious Freedom and Restoration Act. That was, that act, which is now used to cable LGBTQ rights, to cable women's rights. It's the thing that the Supreme Court used in Hobby Lobby to deny women access to health care. That act was passed by Democrats. That was introduced by Chuck Schumer when he was in the Congress. It was championed by Ted Kennedy in the Senate. It was signed by Bill Clinton. That was a liberal act, right? To fix another problem with the law, right? So but the point is that there is nothing that I can say that the conservatives can't twist into something else. That's just the nature of the beast. The point is to stop them. Right. The point is to appoint people, elect people, appoint people, advocate for people who will stop them. Right. You give the Incredible Hulk gamma rays, and he can be an Avenger. He can also ruin your city. It kind of depends on whether or not you brought him onto your side or not. Right. Because the Hulk's gonna smash. The question is if he's smashing the right guys or the wrong guys. That's the battle.
So while we are, at least still a little bit on, the 13th Amendment and involuntary servitude, we have a question from the audience about the argument that has been, discussed in some circles about whether if a state government, forces women to carry pregnancies and go through labor and deliver a baby, should that be considered involuntary servitude in violation of the Constitution?
Yes, I think so. I wrote about it. I think so. I think that forced labor is already unconstitutional. I think that when you talk about forced birth, and remember, when we talk about revoking abortion rights, that's what we're talking about. We're talking about forced birth. We're talking about taking a person who does not want to carry a pregnancy to term and forcing her to do it against her will for up to 9 months for free, against her will. That should be already outlawed under the 13th Amendment. Right, the idea that you could ever do this to a person is offensive to me. My wife had 2 children. I was there. I mean, I watched, right? Seemed hard. After the first one, I was shocked that there was the fact that there are people who have one child and are willing to do it again is a miracle to me, right? It's just a miracle of humanity to me that there are people who are willing to do it. I don't have a word for what it is to take a person who's unwilling to do it and forcing her to do it. There's no word for that. That's illegal. It's unconstitutional. It's barbaric, is what it is. And the idea that we don't already have a constitution that protects us from that barbarism, well, I say we do. And if you think that we don't, well, then clearly the Constitution is trash.
So far we have, discussed specifically the 8th Amendment, 13th Amendment, prohibition on involuntary servitude, 14th Amendment, and Equal Protection Clause. Another topic in the book, which is, very important to ACS, is the First Amendment and weaponization thereof, specifically, with respect to speech, given that we have at least one question, in the Q&A about, the First Amendment speech protections. I thought I'd invite you to share a little bit with the audience about what the book says, with respect to where we've gone wrong on the First Amendment and what a more pluralist conception of it might look like.
Right. So the First Amendment is supposed to be a shield, right? The government wants to make you do something. You use the First Amendment shield. Oh, you can't make me do that. And the government has to say, oh, well, good point, sir, and let you go on with your day. Conservatives are trying to turn it into a sword where they can use the First Amendment to go out and stop other people from doing what they want to do in the privacy of their own home, right? The way that they've done that is that the conservatives have hyped up the idea of the free exercise clause to a point where that free exercise in the conservative mind includes the right to exercise bigotry in the public sphere. Which is not what the First Amendment's about. You want to be bigoted under the First Amendment. The First Amendment will allow you to be a bigot, but you got to do it at home, right? You have to do it outside the stream of commerce, right? You can't just you cannot impose your religious views on other people, because that should violate the Establishment Clause, which the conservatives pretend do not exist. Right? The Establishment Clause is what's supposed to protect a gay person who wants a cake. The Establishment Clause is what's supposed to protect a gay person who wants a job. The idea that somebody else's free exercise, think about Masterpiece Cake Shop, right? So this is the case where the guys, I want a cake, and the baker was like, no, I hate you, and go out of my store, and like that case, right? Think about what he's really saying. He is saying that Jesus ordered him not to take their money, right? Nobody was asking Jack Phillips, the baker, to like jump out of the cake and say, I love gay people. Nobody wanted him to do that, right? Nobody wanted him to come to the wedding. People wanted Jack Phillips to do a thing that he entered in an entire business to do. He went into business to bake cakes. They wanted him to bake a cake and take their money. And he said, no. That's not Jesus, folks. That's not Buddha. That's not religion. That's bigotry. And the First Amendment should not protect that under the Establishment Clause. But conservatives have warped the entire thing, turned it into a sword, and now they use free exercise to allow for additional bigotry, and that's just wrong. And again, the way you fix that is that you have justices who believe in the First Amendment, like, Anthony Kennedy is like Anthony Kennedy ends up being a hero of the gay rights movement. And it's not because Anthony Kennedy necessarily was a fan of gay rights. He was just a First Amendment extremist. He was a First Amendment absolutist, and he understood what free speech, free exercise, and establishment were. He understood how they all worked, and he understood that it couldn't, in most cases, allow for outright bigotry. There are close cases. There are close cases where you could get me to say that, well, I don't know about that, right? I'm trying to think of an example. An artist, right? A sculptor. Hey, you are a great sculptor. I want you to sculpt me and my same-sex partner. Sculpt us in the nude like David, right? I can understand that you could argue that the sculptor's job is speech, right? And you, in the same way that you can't anymore, the tyrant can't anymore first force you to paint a picture of him, right? That would violate the First Amendment. So too, you can imagine a sculptor having a credible First Amendment case if he didn't want to sculpt whatever. I can see that, right? That's different than a baker. That's different than a florist. That's different than a person who produces a repeatable service to just produce the service and take the money and go home. Those are completely different cases. I can distinguish between those cases. I will allow that there are close cases that are harder to distinguish, but what we're fighting about right now isn't one of them, right? Whether or not an employee has to issue a marriage license when her job at the state organization is to issue marriage licenses, that's not a close case. That is just do your job or find another one.
So that has, largely been about the relationship between the Free Exercise Clause and Establishment Clause. Another significant part of the First Amendment is the Free Speech Clause, which, as you were suggesting, has also become, partially weaponized against anti-discrimination protections and civil rights protections, including in, the case that the Supreme Court will hear next term, 303 Creative versus Olenis. But another, as Chief Justice John Marshall would say, perpetually arising question about the First Amendment has been about the relationship between protections for free speech on one hand and, cancel culture on the other. And an anonymous attendee in the chat has invited you to distinguish between free speech on one hand and cancel culture nonsense on the other, and is very grateful for your efforts to do so.
Anonymous indeed, right? No, it's pretty simple. The First Amendment protects us from government, state action against speech. It protects us from government retribution from speech. It protects me and me writing a book from, I don't know, Ron DeSantis taxing me at an extra rate because he doesn't like what's in my book. That's what the First Amendment is supposed to protect me from, right? It protects the freedom of the press. It's supposed to protect I write for the nation. It's supposed to protect my publication. So again, Ron DeSantis can't tax the nation just because he doesn't like what it says. What it doesn't do is entitle me to a job. So if the nation becomes displeased with my works, they are free to fire me. And I have no First Amendment claim, oh, you fired me because of what I said. They could say, yes, we fired you for what you said because what you said is stupid. And that would be that. And then I would have to go to Substack. Like the idea that the First Amendment protects private speech and and prevents private actors from disagreeing with speech is bonkers. That's just not at all what it was intended to do at any point, right? This is one of those examples where if you wanted to be Boromir, you could go back into the original public meeting of the First Amendment, but at no point does it say that the New York Daily Herald has to give a job to Ben Franklin regardless of how many lightning bolts he electrocutes himself with before he writes. That's just not a thing. The idea that the First Amendment protects people or professors who say things that other people don't like is just wrong. There are different arguments for why you should have a professor who says things you don't like, or you should have a TV show by people who are stupid. There are different arguments for that, but none of them are constitutional. The constitutional argument is simply that the government cannot cannot prevent you from speaking. And and you can tell the difference because the people who are most into cancel culture when they say that it happens at the New York Times are the ones who are quietest when it happens at the State House or from the Attorney General's office or from the governor's mansions. They never have anything to say when DeSantis or Abbott or Ken Paxton is trying to ban books from school. No, those Bari Weisses and the Andrew Sullivans of the world, they're quiet when that happens. But when actual First Amendment violations happen, but when something that has nothing to do with the Constitution happens, oh, then they can go off and run their mouth off.
I think one other thing that overlooks is sometimes what some people are describing as cancel culture is actually other people exercising their First Amendment rights to, say, speech, express criticism of views they do not share, or exercising their market power to decline to buy, a product associated with a company or an individual, whose views they do not share. And those are protected forms of speech, at least when some people exercise them, and they should be protected forms of speech when other people exercise them as well. So we have several questions in the chat that are kind of high level overarching thematic questions that I'd love to turn to, if that's okay.
All right.
So one question starts at the beginning of the Constitution, and it begins with the words, "We the people of the United States." And the question is, what should we understand this to mean? How should we explain this to school children?
How should we explain "we the people"?
Yeah.
We should interpret that word "people" as broadly as possible, right? There was a case yesterday where a court ruled that an elephant at the Bronx Zoo was not a person, right? And I'm like, that's a good place to start. The elephant, and I like animal rights, I'm a big fan of it, but the elephant is not a person. People are people. If you can kind of identify the person as a person, then they should have all of the rights and responsibilities that all the other people have. One of the things that I've tried to get people to understand is that fundamentally what Professor Litman as a woman, what me as a black man, what Zendaya as a black woman, I mean, I should say Professor Murray just because of, but I'm trying to be inclusive.
How pluralist of you.
Right. One of the things we're fighting for is to get to where white male landowners were in 1787. That's really all I want. I just want the same rights that white male landowners have had since 1787. I don't think that's too much to ask. And so when I hear the word "people," what I'm thinking is, let's get everybody to 1787, to a 1787 understanding of men's rights, because that would be progress. Which makes you cry when you put it like that.
Yeah, I have to say that is pretty dispiriting.
Not wrong.
Yeah, no, nothing I said questioned the statement as such. So the next question also kind of relates to the status of our democracy and polity. And it is this, in so much as bribery, corporate lobby dollars to politicians remains legal, and basically constitutionalized by the Supreme Court. Can we ever have, any majority of people genuinely interested in the rights of the people, given that politicians who, aren't taking lobby dollars are few and dependent on the folks who are increasingly getting poorer, to support those politicians?
Yeah, so the easy answer is no. Like the easy answer is as long as we have this kind of money in politics, as long as we have justices that will allow for unfettered campaign access, as long as Citizens United is a thing and its progeny are a thing, that we can't really get a fair shake. The easiest way to think about that is no. A more nuanced way I would offer is that part of the problem is that we also have to get liberal billionaires and in the game here, right? When you see a liberal billionaire, you see, what are they going to do? They're going to try to run for president. That's what they're going to do. They're going to try to run for president. Maybe they might make a penis rocket to try to get to some kind of outer space thing, right? But they're going to do these like white male vanity projects. They're not going to buy the court, which is cheap. They're not going to get in the right. Dahlia Lithwick likes to say, when you look at the actual operating budget of the Federal Society, it's not that much. It's $30 million, $40 million. Buying the Supreme Court is cheap, relatively speaking, especially when you kind of pound for pound the power you have if you buy it. We got to get the Tom Steyers of the world to not run for president, but instead do things like fund the ACS, do things like get in the game, compete on judges, right? Like the idea that as much as the billionaire set skews conservative for obvious taxation and also lack of empathy reasons. I mean, like, I don't know what it takes to get $1 billion, but you have to have a certain lack of empathy, I believe, in order to get there. But as much as that set skews conservatives, there are left of center people who have a lot of money. We just don't always put that money where that needs to be. You'll get, and that goes from everybody from the billionaires to the, to the average, I've got $15 that I can give to a candidate. We've got people, think about how much money liberals will give to senatorial races where we have almost no chance of winning. Yeah. Just almost no chance of winning. But it's hard to get people to fund things like the ACS, things that will start to push back against conservative judicial interpretation. It's a harder sell. One of the things that I was really happy with during the Trump era is how donations to the ACLU really ramped up. Like, we should be doing that all the time. The ACLU should be one of the best funded organizations on the planet. The Innocence Project should be one of the best funded organizations on the planet. They're not, but they could be. You just need to, and this goes to the asymmetry that I was talking about earlier. The right wing kind of understands, their leaders have done a very good job of explaining to their base voters how important the Supreme Court is. Right? They're not good at civics. I don't believe that the base conservative voter is any smarter about civics than the base liberal voter. But what I do believe is that the conservative leaders have made a really specific case, right? You want to keep your guns, you got to have the Supreme Court. You don't like two men kissing each other, you got to have the Supreme Court. Like, they tell them that, right? You go to liberals, and for the most part, we say, like, oh my God, we have to elect Barack Obama. He's going to fix things. Yay. Like, it's like we tend to be very savior oriented, right? That we're gonna elect this one guy or one woman, and it's gonna fix everything, right? Without kind of understanding the institutional nightmare that we're up against, and kind of voting and donating with our feet in that way, right? So you had in 2016, you had an open Supreme Court seat. You had an open Supreme Court seat, and a lot of people didn't get into the game, and it's just.
So
that was when.
2016. I want to connect the two things that you said in a specific way, because I am very much, in favor of and support, donations to ACLU, Innocence Project. I think those organizations, are doing phenomenal work. I also think that progressives cannot rely on private organizations or civil society as a substitute for state power and political power. And, you mentioned the billionaire donors, on the left side, they need to take a similar interest in state level politics as, the Koch brothers did and other conservative organizations, because again, like, private organizations are just not a substitute for state power, particularly as we were seeing, some on the right and conservatives brutally use state power to suppress, disfavored minorities, culture, ideas, and more.
As Cersei Lannister once said to Littlefinger, power is power.
Right. Thank you, Cersei Lannister. One other kind of bigger picture question, and I want to include the thank you at the beginning of this question. So the question is, Elie, first and foremost, allow me to say how much perspective your book has given me about the flaws of our democracy. I am wondering what advice you have for those of us who are well aware that we're working within a system that is very broken, and how to stay hopeful when we know that some of the changes we wish to see may never come to fruition, at least during our lives.
I mean, I have 2 kids, so I try to, try to build them up so they can fight some of this. It looks like they're gonna have to. I really, that at some level, this is the hardest question, right? Like, I don't know how you maintain hope given everything that's going to happen. I know that it's crucial to maintain hope.
Yeah.
People need to remember the conservatives didn't start trying to overturn Roe v. Wade yesterday, or when the opinion was leaked, or when Trump was elected, right? They started in 1987. This is a generational project for them. They got burned in Planned Parenthood v. Casey. Souter, I mean, just with the knife in the back in the cloakroom. I mean, like they got burned by Souter and O'Connor on Planned Parenthood v. Casey, and they've spent a generation making sure it won't happen again. And they've won. So to fight them, we're going to have that same kind of generational commitment to the cause. And that's daunting when you put it out like that, especially in our current, world. We're very, if it doesn't wrap up by the next ding ding, then we're kind of lose interest. But we have to have that same kind of generational commitment, generational funding commitment, generational ideological commitment to fighting back against these people who have won the day. They've won the battle. They haven't won the war, as long as we keep fighting it. But that's going to require a long-term fight. And so kind of, is that a hopeful message? I don't know that it is, but it's we have to steel ourselves message, right? There is work to be done now that we haven't been doing. And hopefully this is not the moment where you succeed. This is the moment perhaps where people finally realize how important it is to try. That the third branch of government is just as important as the other two, because it can veto the other two. Other advanced democracies don't work that way. Ours does. We have I would argue, overpowered Supreme Court. So controlling that body, as Mitch McConnell understood. Look, Mitch McConnell does not steal a Supreme Court seat for nothing. Right? He knows what he's buying when he does that, right? And so we need liberals and progressives to start understanding that. We need to start electing senators and congresspeople who understand that. One of the things that I've said is that you can go back to 2015, 2016, right? And you can see Donald Trump coming down the escalator, and he's crazy. He is an anti-establishment guy, and Mexicans are rapists, and I hate women, and I like to have sex with prostitutes. But here's my list of Supreme Court nominees. It's completely normal. It was given to me by the Federalist Society here, and then we're back to the crazy, right? Like, Trump understood that he could not win the Republican nomination without towing a very establishment line on the Supreme Court. Fast forward to 2020. There is not of the 8 Democrats that were kind of in the main in that race, Joe Biden was the most conservative on the Supreme Court, the least willing to think about reform ideas, and it didn't cost him a vote. There has not been a Democratic primary where the Democrat lost for Senate because they were perceived to be soft on the Supreme Court. Dianne Feinstein can go out there and hug Lindsey Graham. It doesn't cost her a vote in the primary. And as long as we have that asymmetry, where even crazy Donald Trump understands that he has to play ball when it comes to the Supreme Court, yet literally no Democrat is worried about dropping a primary or a vote because of the Supreme Court. Until that asymmetry evens out, we're going to keep losing.
So maybe it makes sense to end there, since we are just about at the hour.
Wait, you were going to ask me about my overall ideological philosophy that I can sum up as opposed.
Okay, so what is either the one overarching message you want readers to take from the book, or the ideological message that you would encapsulate and transmit to the progressive legal movement?
14th Amendment or GTFO. Everything should be strained through a 14th Amendment analysis, through a robust understanding of equal protection and due process. Some might call it a strict scrutiny of those clauses, because folks, here's the thing. If your law cannot pass muster with the equal protection of laws, if your idea cannot pass muster with due process and a substantive remedy should that process be violated, then your law or regulation or ordinance or idea is bankrupt. So it's people say like, oh, liberals don't have one overarching I do. I'm a 14th Amendment or all-ist.
I like 14th Amendment or GTFO. We admittedly need like an ism or a ist to be made out of that, but I think we have the building blocks for what to work with.
That's why I wanted to get it in.
Thank you so much. So thank you, Elie Mystal, so much for making the time to do this. If you don't have a copy of Allow Me to Retort, you can get a copy at your local bookstore and also find a way to do so online at the book website page. So thank you everyone for joining us, and thank you again, Elie.
Thank you, Professor Litman.